This is the case of Beach versus Murdaugh and Parker's Convenience Stores. We met for a status conference on Monday of this week. There were some pending motions that we needed to put on the record. And in fact, we had the status conference on the record as well here in open court. There's some pending motions that we needed an opportunity to have more time to deal with and schedule for today. So I think that's what brings us here today. Let me be sure, Mr. Harpoon and Mr. Griffin, we have, who do y'all represent? What is your role? Because we've had some discussion on Monday. Mr. Cook, Dawes Cook has been hired as private counsel for Mr. Alec Murdaugh. What, particularly for the record, is y'all's role?
Yes, Your Honor. For the record, we were retained by Mr. Murdaugh individually to address, in this case, the receivership order and the actions brought by the receiver to disallow Mr. Murdaugh's renunciation of his interest in Maggie's estate. And so that's why we made an appearance in this case. Mr. Harpoon and I also represent Mr. Murdaugh in conjunction with the pending criminal cases. And that's the extent of our role. And in that capacity, we are filing a motion on his behalf to stay the civil case, and Mr. Harpoon will be arguing that. But we do not represent him on the voting action case, on the civil case, whatsoever. And the reason we had already made an appearance was to challenge the receivership order.
Well, let me ask you then, where does that put us? And y'all help educate Judge Hall as far as this hearing today. This is involving what we call the vote case.
Yes, sir.
Everything that's to be done today involves the vote case. And y'all are telling me that you do not represent Alec Murdaugh on the vote case.
We do not represent Alec Murdaugh defending the civil vote case. That's correct.
What, help me understand, what gives you what puts you in a position to come here today to argue about a continuance on the vote case as it affects your client when you do not represent him in the vote case?
Well, we represent him in the criminal case, and the vote case affects the criminal case. We made an appearance in the vote case for purposes of the receivership. Right. And he does not have a lawyer in the vote case.
Well, Mr. Cook indicated Monday that he's representing Mr. Murdaugh personally. Mr. Dawes Cook is representing him on the vote case.
Your Honor, if I might speak?
Yes.
Ask a question. My understanding was Mr. Cook indicated he could not try this case in October. Did he make a conditional appearance? Or is he going to?
I'm not, as far as the argument about when we're going to try the case, we'll deal with that when we need to. I'm just, what gives you the right to speak today in the vote case and put me in a position where I'm supposed to listen to determine about it?
Your Honor, from a legal standpoint, perhaps we're interveners, we're making an appearance because the trial of this vote case will prejudice his criminal case. The criminal judge doesn't have the authority to stay the vote case.
Right.
So the only person that can do that is you, and you're the only forum we can appear in front of and ask you to not do something that will prejudice his January criminal trial.
Okay. All right, that helps. I understand that. You cleared it up.
I mean, I haven't gone to the rules on this, but I'm pretty sure that from a matter of equity, we ought to be.
I don't have an objection going forward today. I just needed in my mind to be clear about where we all stand on that. So with that, then this is a motion. The first motion we'll hear is that Mr. Harpoon and Mr. Griffin, y'all filed a motion for continuance and a motion to stay discovery. I have your motion in front of me. If I'm looking down, I'm going to be following along, so I'm glad to hear you.
Well, Your Honor, I'm not going to, if I please the court.
Yes.
I'm not going to reread our motion. I just want to hit a couple high spots and answer any questions you might have. Clearly, Alec Murdaugh has been charged with murder. We had a hearing in criminal court, I need to put this on the record, in which we discussed a number of matters with the Attorney General. We asked for a speedy trial in October, November. The Attorney General responded that he could not be prepared to do it then, but he could do it in January. I affirmatively indicated on the record I would waive my legislative immunity for January, that we could try this case. And while a judge has not been assigned, nor has a date certain has been assigned, based on that hearing and our continued discussion with the Attorney General, I believe we'll be trying this case in January. So when we talk about not trying this case, civil case in October, we're not talking about some indefinite date in the future. So anytime after January, our issues would be resolved. Now, there may be issues with some of the lawyers in the civil case. I can't address those because I'm not in the vote case. But from our perspective, you know, if you look at all the cases, and I think even after you read the hyperbolic screed the defendant, the plaintiff filed this morning, that's screed, they would concede there's a balancing test here. And that balancing test is a test, Your Honor, you should make. And there are a number of different factors. First of all, it's to the prejudice to the defendant. He has a Hobson's choice. Does he assert the fifth? Now, as we put in the footnote, the cases are so mushy and muddled on whether you can assert the fifth to a question, or once you waive the fifth as to any question, as to have you waived the fifth? Are you forced then to answer? Mr. Griffin and I were talking on the way up here. We both were involved in a case in front of the Honorable Ross Anderson in federal court, where Judge Anderson basically took the position once you answered your name, you waive the fifth. So we've seen it go extremely badly for the defendant in some courts. So if he waives the fifth to defend this case, he opens himself to questioning about all kinds of matters which would be relevant in the criminal case. For instance, so far, the state has not articulated to us any sort of intelligible motive in the murder case. If he's subjected to, either in a deposition or in a trial, open-ended questions that the government, the state can't get because they can't do depositions. What they got when they indicted him, whatever that evidence of a motive is, and we're, based on what we've seen so far, not much, if anything, they would be allowed to use this. I'm not suggesting that that Mr. Tinsley would be a stalking horse for intentionally be a stalking horse for the state, but in effect, by doing his job, he would be. And he and I have been in cases together. He's very effective in the courtroom and in deposition. So it would force Mr. Murdaugh to assert the fifth. And for civil purposes, that there's an adverse inference. We get that. That couldn't be used in criminal court, but it makes him make that choice. Also, if you take the position that they're able to ask him individual questions for which he has to assert individually the Fifth Amendment, there's an adverse inference in the civil case, obviously wouldn't be in a criminal case. But we're trying to try this case in January. The pretrial publicity has been, in my experience, I've been doing this almost 50 years, unprecedented. It continues to be unprecedented. And for him to get a fair trial in Charleston County in January, and the criminal, I must say, I know this is about money, the criminal case is about his life. And a trial of this case in October would make it even more difficult to get a jury in Charleston County. So as you go through the factors, what is the prejudice to the plaintiff in this case? Waiting 3 or 4 months, or in terms of discovery, we obviously would want that stayed as to his deposition. And again, it's a balancing test. I really do think, and I read in the plaintiff's response to our motion, that he says the people of the state deserve resolution. There are competing interests in this criminal matter, but the defendant has a right to a fair trial. He has the constitutional right. He has a right to get a jury that's not so prejudiced they've already made up their mind. This would be difficult enough to do. So, Your Honor, again, our brief outlines in great detail, every case, all the criteria. I'd be happy to answer any, I don't want to beat it to death. I'll answer any questions you might have.
Great, thank you. And I have been through the brief once. We're going to go through it again. My law clerk and I detail before I rule. And I'll rule on Friday this week.
Thank you, Your Honor.
All right, Mr. Tinsley.
Thank you, Your Honor, and I'll try to do the same. I did bring you a copy of the Kramer case for convenience.
You can hand up whatever you need. I do have your,
So let me just respond to those.
I do have your memo in opposition.
Yes, sir. And I think that the memo in opposition lays out the reasons why a stay would be inappropriate. But I want to touch on this. The right to a fair trial. There is no dispute as to the factors that the court would consider. The dispute is that no court has ever found that in a civil context, that the assertion of a Fifth Amendment privilege to a question, the answer of which would incriminate you, is such a burdensome constitutional violation that it prohibits the civil matter from going forward. There's not one. The courts have universally, and our Supreme Court has put, U.S. Supreme Court, as well as our Supreme Court, has put that to rest. But in the Kramer case, Justice Toll laid out very clearly the analysis that the court should employ, and it is a question-specific analysis. You cannot stand up and say, he's going to look bad because he had terrible parenting skills and his son ran amok of the community while under the influence of alcohol, and because of that, we're not going to get a fair trial. That doesn't follow. These two proceedings are absolutely not parallel. This is not a case where the Attorney General has instituted a civil matter and a regulatory enforcement matter, a criminal case at the same time. They cannot articulate one single question that could be asked that relates to murders that happened over 2.5 years after Mallory Beach died. After the indictments were entered, July the 14th of this year, they answered the Third Amendment complaint in this matter. They did not assert the Fifth Amendment. They don't have to assert the Fifth Amendment, but they have responded. And our court makes it clear in Kramer that you can fight the civil case. You can defend the civil case. And I understand they're confused and in their footnote. But if you read the Kramer case, the Supreme Court makes it very clear that you cannot unintentionally, accidentally waive your right. You have two very capable, the bulldogs of the criminal defense bar, and I'm saying that in all due respect to both of them, who could assert and tell him to assert the Fifth at the appropriate question, if a question were ever asked. Now, if we were talking about in the Satterfield case, the theft of Gloria Satterfield's money, which they admitted he stole, that they confessed a judgment, that he's in part disbarred for that, I could see how that assertion of the Fifth Amendment to what you did in that case could be applicable, but not here. I mean, the closest they could ever get would be, where is the money? To which that might incriminate him on some other criminal investigations that are going on. But this has been going on for a year and a half, 18 months of multiple investigations that have gone on, and one more deposition, Alec Murdoch's deposition, which Mr. Parker has indicated he intends to take, is not going to prejudice Alec in any way. And if it does, I think the appropriate remedy is for the court to take it up after the question is asked and the defense is asserted. And I don't believe this is appropriate, but I believe that you could enter a protective order on the deposition if that came up. But first, an objectionable question has to be uttered. Just because you look bad does not give you a right to stay in a civil proceeding. Waiting 3 or 4 months is not what they asked for. They asked for the conclusion of the criminal prosecution. The death penalty assault, this is not going to conclude in 3 or 4 months. And the significance of the prejudice is there are multiple lawsuits against Alec Murdoch, which he is not defending. The receiver is currently defending. Nautilus Insurance Company has sued him in federal court. The receiver has answered because Alec Murdoch is not answering. They're suing for the $4.3 million in attorney's fees arising out of the payments made in the Gloria Satterfield case. They don't even have damages, Your Honor. They made a voluntary payment. They never paid any more money than they bargained for in 2018 and 19, and yet this lawsuit is going forward undefended by Alec Murdoch. We are going to suffer prejudice, and it is not just a delay in the resolution that this family needs. The Kramer case is very clear, and in Kramer, on page 7 of the, beginning with that, the witness is not exonerated from answering. The court goes on, and I'm just going to hit the high points and so you can see, but the next page, the more difficult question, they begin to talk about the fact that all of this discovery is not covered by the privilege. Assuming that, in this case, if you recall, this is one of the cases I argued to Your Honor for the receivership. This is where money was misappropriated. The Kramers were being sued. And some of the questions were, where's the money? And so the answer to that question would acknowledge that they had the money, and so they objected to that. Well, the court in the Kramer case goes on and says that all of the focus in the discovery was not so directed. Other areas which do not implicate the Kramer's relationship with the Breedloves or the transfers of assets of the relationship, those are not covered, and those answers to those questions would not implicate. He doesn't get to assert the fifth on his name, his address, his relatives, anything, the answer of which does not implicate him in a crime. Now, they have this discovery where somehow we're going to help the Attorney General by taking this one additional deposition, and somehow the relationship between Paul and Alec, or Paul and Maggie in 2019 would provide the motive for why he might have killed them in 2021. We asked questions about that with a request to admit that were answered by Alec Murdoch about the knowledge of Paul's consumption of alcohol, about the fact that Maggie had spoken with Paul that night at midnight when he was highly intoxicated and driving the boat, and she knew that. So he's answered questions. There is testimony in this case that to ask the question again couldn't possibly serve as a basis for prejudice. For all the reasons in my brief, for the reasons that are outlined in the Kramer case, I would ask the court to deny. If you were inclined to do anything on this issue, I would say allow the deposition to go forward, enter a protective order so that it remains sealed until the appropriate time if the privilege is asserted to an answer to a question. Because the Kramer case makes it very clear, that is your determination. It is not the defendants who determine that the answer would in fact criminate. Now, there's a high burden. You have to show some deference. But if it clearly doesn't apply, for instance, what is your name, where do you live, who are your relatives, things like that, the privilege doesn't apply to that, Your Honor. Thank you.
All right.
Your Honor, very
Let me do this because you might want to answer my question, and then I'll give Mr. Tinsley an opportunity to answer. I guess I have a couple of questions that seem more basic just as far as procedurally and where we are. Is that two things have happened since we set the trial date. And we set the trial date a couple of months ago. We set it for October. Everybody agreed to October. One of the lawyers who agreed was John Tiller, who was representing Alec Murdoch. He is now deceased. He died a terrible death. We all knew he suffered pancreatic cancer. He has died. Mr. Yance, and may need to address this, was here Monday. He and Ms. Condon were asked to be relieved from representing Alec Murdoch, not because of John Tiller's death, but because of the second thing that's happened since we set the trial date. The second thing that's happened is that one of the defendants, Alec Murdoch, has now been indicted for murder. That had not happened when we set the case for trial. and in fact, he's indicted for murdering a co-defendant, which makes those two issues, I'm really more concerned about those two issues and timeliness of being able to now try the case 6 weeks from now than I am necessarily with wading in too much of the rights. I may have to do that. But I guess where we are practically, and I'll come back to you, if you don't mind, Mr. Harpootlian, Mr. Yachts, where do we stand as far as your firm initially represented Alec Murdaugh, and I signed an order allowing y'all to withdraw, and y'all are going to continue to, and I believe Mr. Overstreet and Mr. Coates was here Monday indicating Mr. Overstreet would be representing John Marvin Murdaugh as the personal representative of Maggie Murdaugh's estate, and then Bill Coates indicated that he would, well, there was some, they weren't quite sure, depending on when the case would be set for trial, but he was going to likely be representing Randolph Murdaugh IV as personal representative of Paul Murdaugh's estate. So where are we, Mr. Yachts? Do you have any idea where we stand? And Mr. Harpootlian, that's why I asked Mr. Harpootlian and Mr. Griffin, did they represent Alec Murdaugh? They've been in the civil boat case. So as of right now, Mr. Coates indicated that Mr. Cook indicated that he was hired by, he said that here at the court, he was hired by the law firm, the Murdaugh law firm, to make sure that Alec Murdaugh's interests would be protected. He was not ready for trial. So where do we stand as far as what y'all were doing for Alec Murdaugh, what Mr. Tiller was doing, and is there anybody that you know in place to take over that aspect of the case?
Okay, Judge, thank you. Yes.
And am I clear on where we are on everything?
Absolutely. You've done a great job explaining the history of what's happened over the last few months. Dawes Cook was retained some time ago, correctly, as he said on Monday, to be personal counsel, and that actually was when Mr. Tiller was first diagnosed with the cancer. So there was kind of a question of how he was good on his condition and all that. Well, he actually was doing very well, and so Dawes never was in the forefront, involved in the litigation. John in our office was lead counsel for Alec and Buster at that time. In February of this year, the third amended complaint is filed, and for the first time, Paul and Maggie are added as defendants to the case. So that was in February. So now, as you correctly pointed out, the indictment went down July 14th. And so as of this week, we have withdrawn representing Alec, and I'll start with Alec. Mr. Cook was counsel but not really involved with the case, but is now willing to step in and get up to speed and become Alec's lead counsel in the boat case. But because of an issue in October with the vacation, that is a problem. But he has not been involved in the case at all.
Okay. All right. So what you're representing in court is Dawes Cook, in essence, is stepping into Mr. Tiller's shoes and his involvement representing Alec Murdaugh.
That's correct.
Okay. And I think Mr. Cook was here Monday and indicated he had permission from the court not to be here for this hearing today.
That's correct.
Okay. All right. I'm clear on that.
Okay.
So he has representation, Mr. Cook.
Correct.
All right. Now, I think that brings us, y'all got me all straightened out in my mind, brings me back to Mr. Harpootlian.
Other than the October, but Mr. Cook told you, I think if you recall on Monday, the issue, the conflict he has, personal conflict, for trying the case in October, but he can't get around. So there's that as well that was discussed on Monday. And then I can talk about the other defendants and their potential substitute counsel.
Well, I think I was pretty clear on Monday about they're just now brought into the case as substitute counsel and their role in that period of time being ready in October.
Okay.
All right, I think I'm clear now, Mr. Harpootlian, I'll throw the ball back in your court.
Mr. Second, first, Mr. Tindley indicates, his criminal matter will be gone, going forever. Once a verdict's returned, his Fifth Amendment rights are gone. Appeal, of course, I don't think there's going to be an appeal because he's going to be acquitted. But if there was an appeal, that would not stay this trial. Secondly, the case, and we cite the same case, interestingly enough, that he keeps pointing to, the Kramer case, and it stands for the proposition that we should infer is that you can't assert on everything. We get that. I guess, and it is a balancing test, Your Honor. But what I would say is, based on what I've heard today about the status of the counsel in the case, maybe you don't even need to reach this issue. Maybe you can resolve it based on just the logistics of what you're facing on a trial in 6, 8 weeks, where somebody's just getting into the case, other folks have just substituted in. I'm not suggesting that you not reach this issue, but because we would like it to apply, we'd like you to apply what we've asked as to any sort of deposition. The answers to interrogatories that Mr. Tingley referred to were before he was indicted. So now that he's been indicted, he has, I believe, the ability to assert, obviously assert, but he probably could have asserted that if he knew he was going to be charged with crimes. But now he's charged with murder. It's going to be tried in January. It will not impede this court, won't impede Mr. Tinsley from getting this matter before a jury. And Your Honor, to try this case a few weeks before we try to pick a jury in Collin County will deny or even allow, and he's talking about sealing the deposition. I don't know that anybody's agreed to do that other than Mr. Tinsley. Or they could just sever out Mr. Murdaugh out of this case. I mean, he doesn't add the real, look, let's talk about who the real target is here. Joint and several as partners. They got the insurance. Oh, Murdaugh doesn't have any money. Every penny he has, Your Honor, signed the receiver that seized it. There's no money there. So I would suggest severing him out, maybe the easiest way. Of course, I'm not in a position to make a motion to sever because I don't represent Alec Murdaugh in this case. But perhaps Mr. Murdaugh's lawyer may ask to do that to protect, not put him in the Hobbs' choice of asserting the Fifth, having that question inferred, the inference from the asserting the Fifth is he would have, it should be held against him, whatever it was. That's the problem. You know, did you give Paul alcohol? Assert the Fifth.
All right. Thank you, Mr. Russell. Mr. Tinsley, I'll give you the last word.
Yeah, thank you, Your Honor. As I argued to you in the receivership motions, that there's no money there. There certainly is a lot of fighting that goes on to not be any money there. I think that if I'm being completely candid, Paul and the estate of Paul and Maggie were added solely because of this disclaimer issue and solely because of the shenanigans that were going on with respect to the estate, which is in fact Alex Murdaugh. I mean, in other words, there's no estate. Paul has, it's all Alex Murdaugh's, whatever there may be. And because of what they were doing and the disclaimer and the other things that they were trying to do, that's why they're added. Now, if we're going to sever something, and I'm sort of talking out loud, my inclination would be, and I don't see any prejudice to anybody, if we sever the estate of Maggie and Paul out of this matter. We try the case. Dawes Cook has indicated he can try it in November. It sounds to me like Your Honor's not inclined to stick with the October 3rd date. Even though when we had that hearing, the estates were parties to this action. Because, again, the estates aren't the issue. Alex Murdaugh has always been the issue. And that's what's going on. We would like to get the case tried. We would like to get the case tried this year because we then run into the Merle Smith issues. We're going to run into Mr. Coates, who's a very good lawyer, that says, I'm going to need 9 months. So we're going to drag this out for another year and a half, and it's going to go on, and it's time for some closure. We've been waiting since June of 21 because of the murders. And we simply waited long enough, Your Honor. The beaches need some closure and they need to begin to heal. So,
All right,
thank you.
thank you. Well, here's what I'm going to do. We're going to continue the case. And I'm more concerned, and I'm with Mr. Tinsley. The court certainly would rather this case be resolved sooner rather than later. However, you know, two things that are completely out of the court's control are the death of Mr. Tiller. The other things completely out of the court's control is the indictment of a defendant, Alec Murdaugh, and the murder of a co-defendant, Paul Murdaugh. Again, those two things have happened since we set the case for trial and agreed for the case to be tried in October in our last meeting. And again, that's not something that this court has any control over. However, they're real facts. That's where we are. And so to ask the new attorneys, including Mr. Cook and his role, to be able to be brought up to speed between now and the October trial date would be unreasonable. And I believe that would be an abuse of this court's discretion in requiring them as option of the court to be ready on that type of notice. Now, I will say that when I say it's continued, if, and there again, we're just talking out loud, if the other parties were severed and this boiled down to the Parker involvement, it appears that part of the case is ready to be tried in October. But that's not for the court today. And if that's something the court needs to address in the next week or so, just let me know. If there are other motions that might lead to that, on the other hand, that's not the court's responsibility to make those decisions, trial strategies. I just leave that out there. Whatever we can try in this matter, as soon as we can, the court will do everything we can to do that. I think then that would leave us with, we need to have another status conference, very likely in sometime in October, to get an idea where we are and try to set another trial date. The case will not be tried as it stands right now between now and the end of the year, unless something else happens. But we'll restatus it in October. The issues about discovery, I don't know whether the court needs to rule on the motion to stay discovery. That was sort of brought as a general rule. Just when it says stay discovery, I'm not sure how extensive. I know what the Mr. Harpoon and Mr. Griffin wanted the discovery not to require their client to be subject to a deposition. I don't know if a deposition's been scheduled or an attempt to depose him has been scheduled. And so I'm not going to deal with that issue unless it comes up. Again, if right motions are filed, I'll work with you. We'll hear those as soon as possible. I'm pretty flexible. The Supreme Court's given me the authority to hear any of these matters anywhere in the state whenever they need to be heard, so I'll do whatever I can to accommodate. So I think that sort of, do I need to issue a rule, Form 4 order continuing, or is everybody happy with just a ruling from the bench?
I'm not happy at
I
all.
know you're not happy, I'm not asking that.
Yeah.
But happy is probably not. Procedurally, does the court need to file at least a Form 4 order granting a continuance?
Not for my purposes, Your Honor, but Mr. Harpoon.
No, sir. Form 4 is fine.
No, I think he asked.
I'm asking, do I need to file a?
Oh, no. I mean, we don't need an order.
Everything we've done is out here
Yes,
on the open,
yes.
on the record.
Yes, sir.
I don't know that there's anything else that needs to be done.
Nothing.
Put in writing as far as that.
Nothing. No, Your Honor.
All right, Mr. Welford, you rise.
Yes, Your Honor. May it please the court, David
I've
Williford.
already resolved our issues on Monday.
I know. Just for clarification from the court in terms of discovery, I know you just addressed that. That was in the motion from Mr. Griffin and Mr. Harpootlian. We would like to proceed with discovery. We have depositions.
I have, I'm not going to rule on the motion. The discovery was limited today to what I heard, Alec Murdaugh. I'm not going to rule on that. I'm not going to issue an order, a broad discovery order that discovery is stayed. I'm not going to do that. I don't think I need to. Do I need to do anything that formally?
No, Your Honor, I think you answered it and just wanted to see the court's comments.
Okay.
I think we're all set.
As far as the court's concerned, discovery in the boat case needs to continue on the schedules that has been set. And it appears that on the boat case, there has not been a deposition scheduled as far as Alec Murdaugh. If that becomes an issue, I'll listen to those arguments if that motion's made.
Your Honor, just for the record, if a deposition notice or discovery was served, Mr. Cook will deal with that. Of course, we communicate. We'll communicate, make sure he communicates with his client about his desires. I suspect it'll be a motion to quash.
So does that mean that this court will not see Mr. Harpootlian and Mr. Griffin in our courtroom?
I doubt it, Your Honor.
Well, Your Honor, I can't promise, but there's really nothing here for us. So,
I understand your role. I mean, and I appreciate that, and that's where we are.
so, and seeing Mr. Tindley just really makes my week.
All right.
Second.
You know, Mr. Tindley and I litigated cases on the same side several times, so we're
He's not as bad all the time, Judge.
All right. Well, we want to move the case as quickly as possible. I think that's my role when I was appointed to move it as quickly as possible. But on the other hand, as we all know, in this particular case, there has been a book of unusual things that have happened since the case was filed that are completely outside of the court's control and outside most of the attorney's control. So we will deal with those that have come up and that may come up in the future. So that's, I think we're all on the same page where we
Yes.
are right now today. All right.
And Judge, I mean, you brought up the severance or the bifurcation, and so, I mean, can we have a conversation, much like a status conference, about some of this? Because there's, Buster Murdoch is a defendant. Buster Murdoch has counsel that's been involved since day one. I assume they're still ready to go to trial because they've not left.
Yeah, my suggestion, y'all talk about that among yourselves. And if that's an issue that the court needs to be involved in, then bring it up. If a status conference needs to be held on that, I'll be glad to do that. I'll tell you that all status conferences that the court has will be on the record, out in the open. Discussions y'all have among yourselves, that's, the world's not entitled to know what lawyers are talking about among each other. But if you're asking the court to be involved, everything we're going to do will be here out in the open.
Well, I guess I'm asking the court your inclination. You've indicated that there were certain things beyond your control. The indictment was one of those. Does that mean there's no set of circumstances? Because Dawes Cook had indicated he would be ready to try the case in October, but for his vacation. He is ready to try the case in November. And so, but if I'm trying to understand.
No, I agree. If the attorneys agree that there's a portion of this case that can be tried, and y'all agree on the court date, I'll make it happen.
Okay. Well, I'll talk to them and then.
Well, I try to. I'm just trying to do what other people do. All right. Anything else?
No, sir, Your Honor.
All right,
Thank you.
thank you.
Thank you for accommodating me on Monday to do this today.
All right, thank you.
Thank you, Your Honor.